Prosecution witness number 326 believes the events that unfolded inside KICC preceded the post-election violence and proved to be the catalyst to the violence, which he firmly believes was spontaneous. He narrated to the chamber that before the results were announced and in the full glare of the media, the Orange Democratic Movement's Pentagon members and Party of National Unity's bigwigs, police came in and started getting people out. He went on to add, and I quote, "They picked the Electoral Commission chairman, rushed him to State House, and in less than 10 minutes declared the then sitting president the winner." End of quote. That was the last straw, according to the witness. He says, quote, "Violence just broke up because the electorate did not expect the results, much less the way they were announced." End quote.
Mr. Witness, good afternoon.
Deputy President William Ruto's defense team got the first opportunity to cross-examine the witness. Khan's tactic, it appears, was to prove within the first few minutes that Ruto couldn't have been criminally responsible for the violence as alleged by prosecution.
You attended, you say, a large campaign rally at Uhuru Park in December 2007. Do you remember saying that, witness?
Yes.
And I think you were quite clear that that was the last campaign rally.
Karibu! Agwambo! Karibu! Ruto!
The witness, being passionate about politics, was among the estimated 1 million people who attended the rally, as well as another equally huge rally that preceded it in Kitale.
You never heard anything from William Ruto amounting to incitement, did you?
No.
Khan is expected to conclude his cross-examination of this witness around midday tomorrow, but there was another sticky issue pressing the prosecution.
The witness who was scheduled after that was witness P438. We've encountered logistical issues with that witness, which will delay the travel of that witness to The Hague. The following witness we intend to lead is witness 356.
I alerted my learned friend this morning that it puts us in difficulties.
We had not expected that this witness would be moved so much high up.
We've tried to prioritize our investigations in relation to the original witnesses, the order of witnesses we had been given. This witness is quite massive. There's, I haven't counted exactly, but volumes of transcripts to go through. And it's also complex defense investigations that are required, that are time-consuming.
His mention of Mr. Sang is to a very substantive extent, and we would really make good use of more time if we were afforded.
VW perhaps be informed to vacate the travel that's been booked, and for the prosecution to use their best efforts to fill that time.
I undertook to look into that. From my initial consultations, it seems that that's going to be difficult because the VW have already booked tickets and got visas, and the process is already in order.
That being the case, the judge asked both teams to suggest options to ensure proceedings carried on uninterrupted.
My preference always is to have a witness be examined in chief and cross-examined immediately thereafter. But, Your Honour, again, in a league of options, if the prosecution cannot put the witness back to give us the time that we need, and if the court then was not minded to grant an adjournment because that wasn't possible, then the least worst option would be prosecution be given leave for the witness to be called to give evidence in chief, and to go back, and for the defence to be given leave to recall him and cross-examine him once our investigations are where they should be.
In the world of options, that would probably be the prosecution's least preferable option, because experience has taught that lengthy delays between examination and cross-examination are not fair to the witness and are not in the interest of the search for truth.
Presiding Judge Chile Eboy Osuji said the chamber will rule on the matter tomorrow, but encouraged the defense and prosecution teams to engage each other further on the subject. Sylvia, Chebet, Citizen Live at 9.